Hello, everybody, and welcome to the National Paralegal College Faculty's Legal Analysis of the News for today, and that is February 2nd of the year 2012. And today we are going to discuss an issue that is very, very much in the news, and that is the issue of the super PACs, the Super Political Action Committees. As you can see over here in this article, a pro-Romney super PAC rakes in cash from California donors. Of course, a super PAC is really just a colloquialism. It's not an official legal term. It's really just a name for a really big PAC. And a PAC is a political action committee, which is something that tries to lobby politicians to get some kind of agenda that they would like passed. Well, what a super PAC is, at least in the context of this race, is a really big PAC, a really big political action committee that tries to help candidates win, presumably because these candidates will be a little bit better for their agenda. In fact, if we look at the definition of super PAC, and this is taken from Wikipedia, not that Wikipedia is a primary source for anything, but still, it can be useful. The 2010 election, a couple of years ago, and of course the 2012 election as well, marked the rise of a new political committee, the super PAC, and officially known as an independent expenditure-only committee, which can raise unlimited funds from corporations, unions, other groups, as well as individuals. The super PACs were made possible by two judicial decisions, the U.S. Supreme Court case in Citizens United versus Federal Election Commission, and a subsequent lower court case in SpeechNow.org versus the Federal Election Commission. And what I want to discuss today is a little bit about these super PACs, and especially about the Citizens United case, which, at least according to this Wikipedia article, made these all possible. And of course, as to be expected, the media is all over this whole issue with the super PACs. In fact, this article is, I think, from NewYorkTimes.com that I found it. This is basically an implication, not so much an implication, an actual statement, that this entire super PAC phenomenon is really a result of the Citizens United case from a few years ago, and that's really going to be the topic of our discussion. You can see over here where the Times, at least this particular columnist on NewYorkTimes.com, says that 45% of all ads airing in Iowa were directed against Newt Gingrich, and that financing for these ads came from, the other candidates, and Restore Our Future, a super PAC that backs Mitt Romney. And of course, other big donors have been in the news. This actually is also an article from a person by the name of Sheldon Adelson, who I guess gave a lot of money, millions of dollars, I think about $10 million, to a super PAC that supported Gingrich. And of course, so all the focus of this discussion is from a Supreme Court case that happened a couple of years ago called Citizens United versus the Federal Election Commission. So let's take a look at that case a little bit, and then I want to discuss it, and a little bit later on we'll actually look at the language of that case. It's always good to look at the language when you're discussing a case. This is an article that came contemporary from when the article came down, from when the case came down, the Citizens United case came down. And in this case, the United States Supreme Court, in a very close 5-4 decision, ruled that the government may not ban political spending by corporations in candidate elections. Of course, the proponents of the decision said that this was a vindication of First Amendment rights. People, and according to Citizens United, corporations as well, have a right to free speech. And free speech includes the right to give money for a particular candidate. Just like I have the right to go out there and say that I support a candidate, I also have the right to finance a candidate. At least that's what the Supreme Court said. But this didn't necessarily apply to giving money specifically to the candidate. Giving money to candidates is still restricted and can be still restricted. It was not actually affected by the Citizens United case. The Citizens United case specifically went to the idea of funding these organizations, now called super PACs, that support candidates or attack candidates but aren't directly related to the candidates. The Citizens United case, reversed part of a 2002 act called the Bipartisan Campaign Reform Act. of 2002, although it's sometimes just known by McCain-Feingold, because the reason why it was called bipartisan, at least part of the reason, is because McCain was of course a Republican, Feingold a Democrat, and they combined to sponsor this bill. One of the things that McCain-Feingold did, that this act did, is that it banned the broadcast on cable or satellite transmission of electioneering communications paid for by corporations or labor unions from their general funds in the 30 days before a primary or in the 60 days before an election. So, in addition to having restrictions on how much money can be given to a particular candidate, individuals are limited only to a few $1,000s, and corporations can't give money directly to candidates at all. The Bipartisan Campaign Reform Act said, in addition, you cannot transmit electioneering communications within the last 2 months before a general election or within the last 30 days for a primary election. As you can see in the second half of this piece of the article, already in 2007 the Supreme Court had limited this to only communications that are susceptible to no other reasonable interpretation other than as an appeal to vote for or against a specific candidate. In other words, even before Citizens United, a person or a corporation or pretty much anybody was allowed to spend an unlimited amount on issue ads, on issue campaign ads. For example, if some group wanted to support a tax proposal that, let's say, for example, President Obama was putting forth, it couldn't specifically say within the last 60 days before the election, vote for the Obama tax proposal, but it could have said, this idea is a really good idea for reason XYZ, or the other candidate's idea is a really bad idea for reason ABC. And moreover, so Citizens United changed that. Citizens United essentially said, as long as you're not giving money to the candidate to him or herself, as it says over here in the same article, the opinion didn't disturb the ban on direct contributions to candidates. But as long as you're not giving the money directly to a candidate, if you are a corporation or you are an individual, you can pretty much give as much money as you like to an organization, even if they are specifically attacking a candidate, or even if they're appealing for a vote for a particular candidate. It also should be noted, this is very important as well, that this entire issue, the entire Citizens United case, was really only about corporations giving money. Individuals were already allowed to give money from several years earlier. There was a U.S. Supreme Court case all the way back in 1976 called Buckley versus Vallejo, which had already said that if you're an individual, you have unlimited rights, essentially, based on free speech, to sponsor a particular ad against or for a particular candidate. Again, contributions to candidates, they can and still are, they still can be restricted. But when you're talking about an individual putting on air a particular political viewpoint or paying for a particular viewpoint, as far back as 1976, limitations on that were declared unconstitutional. In that case, the U.S. Supreme Court said that the limitations on campaign expenditures were unconstitutional because they place substantial and direct restrictions on the ability of candidates, citizens, and associations to engage in political expression that was protected by the First Amendment. And there is a lot of confusion on this front. There are people that, even that New York Times article that we just saw, at least part of it, implied that the existence of PACs, the existence of these super political action committees, is because of Citizens United. But as pointed out in this letter to the editor, which is based on that article that I showed you before, the existence of super PACs itself, as long as they're funded by individuals, would have been allowed even before Citizens United, and even under McCain-Feingold. Because as this person points out, the Citizens United case doesn't deal with wealthy individuals in that case. That was a 1976 ruling by the Supreme Court in Buckley versus Vallejo, which concluded that since debate on the qualifications of candidates was at the core of our electoral process and our First Amendment freedoms, individuals could not be limited in the independent expenditures that they made endorsing or denouncing candidates. And in fact, if you look around also a little bit, there's a lot to be said, or there's certainly many theories out there, that the main movers and shakers behind these super PACs are actually individuals. So, well, this is the same article over here. The Citizens United case dealt with a different subject, the rights of corporations and unions to fully participate in the political process. But if you look at this article, this puts forth the theory that individuals are driving the super PAC financing. Sheldon Adelson, for example, that contributed $10 million to a Newt Gingrich super PAC, is obviously an individual, not a corporation. And you can see over here where this same article illustrates that many wealthy individuals very often are the driving force behind super PACs. And you may recall in 2004, this is of course before Citizens United, you had sponsorship of the 527 groups. The 527 groups were essentially not directly affiliated with a candidate. You may recall the most famous of the 527 groups, the Swift Boat Veterans for Truth, that attacked John Kerry based on his record in Vietnam. And those, of course, weren't sponsored by corporations, but they were sponsored by individuals. They were paid for by individuals. They received money from individuals. They weren't directly affiliated with the candidate, and so therefore, even under McCain-Feingold, even under the Campaign Reform Act, even before Citizens United, those were certainly allowed. And as you can see to this day, there are still wealthy individuals that are, as this says over here, the biggest Golden State donor to Restore Our Future, which is Romney's super PAC, is a particular individual that gave $350,000. So you're talking about a lot of money that's being given to individuals. Okay, so we've taken a look at a little bit about how the news media has covered the case and maybe some of the ramifications. Now let's take a look at some of the language from the case itself. Of course, the original one was the case we looked at a few moments ago. That was the Buckley versus Vallejo case. That was a famous case that's kind of the grandfather of all these more recent cases because it put forth the proposition that freedom of speech doesn't only mean actually putting forth ideas. It also means paying for other people to put forth ideas. That was really the contribution of Buckley versus Vallejo. Now, of course, McCain-Feingold, I think it could have been reasonably argued at the time, and it certainly was reasonably argued at the time, and many people still think that it does not violate Buckley, it does not violate this particular concept, because that case, the McCain-Feingold, applied to associations and corporations. And if you subscribe to the idea that associations and corporations do not have the same First Amendment rights as individuals, then McCain-Feingold could have been perfectly consistent with Buckley. But, of course, that's not what the Supreme Court decided in the case that we're looking at, and that's the Citizens United versus the Federal Election Commission case, which occurred in 2009. So let's look at the Supreme Court's language in this case, in the Citizens United case. Well, before the Bipartisan Campaign Reform Act of 2002, I'll just refer to it as McCain-Feingold, before it, federal law prohibited, and still does prohibit, corporations and unions from using general treasury funds to make direct contributions to candidates. What the BCRA did, what McCain-Feingold did, is that it prohibited any electioneering communication as well. And an electioneering communication is defined as any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office. So, for example, even before McCain-Feingold, you were not allowed to give money to a candidate if you were a corporation, or beyond a certain point, beyond a certain amount if you were an individual. After McCain-Feingold, before McCain-Feingold, you were allowed to give money to a particular issue ad. You were allowed to give money to a political action committee that was going to argue in favor of a particular candidate's tax proposal or a particular candidate's foreign policy, or argue against a particular candidate's foreign policy. What McCain-Feingold did said you can't refer to a specific candidate. If you're a corporation, you can't give money that refer to an ad within 30 days of a primary or 60 days of a general election that refers to a specific candidate. And the Supreme Court eventually struck this component down. The Supreme Court said this essentially is going to stifle the ability of organizations to get their political viewpoints out. The Supreme Court gave some examples over here. What if the Sierra Club runs an ad within the crucial phase of 60 days before a general election that exhorts the public to disapprove of a congressman who favors logging of national forests? Or the NRA publishes a book urging the public to vote for a challenger because the incumbent senator supports a handgun ban? Or the ACLU? Or whatever it is, and the court observed that these prohibitions are classic examples of censorship. Now notice, of course, the Supreme Court, all the examples over here are examples of associations, of nonprofit organizations, nonprofit associations, but the Supreme Court wasn't only limiting its decision to nonprofit organizations and associations, the Supreme Court was applying this kind of thing to any corporation. And the court said that political speech does not lose First Amendment protection simply because its source is a corporation. The identity of the speaker is not decisive. Anybody, whether it be a corporation or an association or an individual, corporations and other associations, like individuals, contribute to the discussion, debate, and the dissemination of information. And so therefore, the U.S. Supreme Court has rejected the argument that political speech of corporations or other associations should be treated differently simply because they're not natural persons. And in fact, I cut it over here because it's a little unwieldy to look at, but when the Supreme Court wrote this, it cited about 15 cases from previous times, which I guess also subscribe to the idea that corporations have rights, just like individuals do. And of course, Citizens United had devastating implications. It was the Supreme Court case that reverberated around the country for a long time, and still to this very day, years after it's been decided. In the immediate aftermath, this article said that 24 states' laws are open to attack after the campaign finance ruling in Citizens United, because many states had copied McCain-Feingold or had similar rules that also restricted the ability of associations and corporations from contributing. And of course, since Citizens United was based on the First Amendment to the U.S. Constitution, it's binding on everybody. And because of that, many people in Congress, especially Democrats, were very upset at this idea. They felt that corporations are going to have too much influence. After that, congressional Democrats actually went so far as to try to get legislation passed aimed at undoing the U.S. Supreme Court decision. Now, of course, Congress has no power to undo a U.S. Supreme Court decision directly, because the Supreme Court is the ultimate arbiter on what the United States Constitution says or means. But what certain congressional Democrats proposed, at least, was to impose a patchwork of spending restrictions and disclosure requirements, basically make it so onerous. Say, okay, if you're a corporation or an association, you can go ahead and finance these things, but we're going to make you disclose all this information, we're going to give you all sorts of restrictions, and we're going to try to make it as difficult as possible for you to go ahead and do that. And the measure would have greatly expanded the scope of an existing ban on political commercials paid for by foreign corporations. It would have banned political commercials paid for by government contractors. Now, as a matter of fact, this thing didn't pass. If it would have passed, of course, it probably would have gone back to court, and who knows exactly where the Supreme Court would have drawn the line between restrictions that are allowed and restrictions that are not allowed. But you can see the kind of backlash there was. In fact, the backlash of congressional Democrats pales in comparison to the backlash of the Montana Supreme Court. The Montana Supreme Court had actually had a similar rule to McCain-Feingold, probably a little bit more strict, if anything. And in that case, there was a case brought just recently. I think this decision came down on December 30th, 2011, so really just a few weeks ago. And what happened in that case is the plaintiff wanted to spend corporate funds to independently support or oppose political candidates, and even though it was prohibited by a particular Montana statute, and the plaintiff, who wanted to spend the funds, said, and the district court agreed, that the statute was unconstitutional based on the Supreme Court's decision in Citizens United. And the Supreme Court of Montana reversed. Now, the Supreme Court of Montana, as you can see in this overview, tried to distinguish it a little bit. Montana had a compelling interest in preserving its system of elected judges. Whatever. The point is that the Montana Supreme Court did try to distinguish it from the Citizens United. But if you read the opinion, and you can see the site over here if you want to go ahead and look it up, or you can Google it, I'm sure you can find it. The opinion at first tried to start distinguishing Citizens United from this case and say why it's different, but then the opinion kind of dropped all pretenses and just went after the U.S. Supreme Court, and the judge actually had the audacity, so to speak, to say, as a member of this court, I'm bound to follow Citizens United, but I do not agree with the Supreme Court's decision. I do not have to agree with the Supreme Court's decision, and to be absolutely clear, I do not agree with it. And then went on, and then said in the end, a little bit of a shot at the Supreme Court, it defies reality to suggest that millions of dollars in slick television and internet ads put out by entities whose purpose and expertise in the first place is to persuade people to buy what's being sold carry the same weight as the flyers of citizen candidate, etc. And then it went so far as to call the United States Supreme Court utter nonsense. It is utter nonsense to think that ordinary citizens and candidates can spend enough to place their experience, wisdom, and views to keep pace with the virtually unlimited spending capacity of corporations. So you can see, and again, I don't know specifically, I guess Montana is a little bit more of a libertarian leaning area, so maybe they're hostile to corporations. I don't know exactly where this decision is coming from. But you can see that there is a tremendous backlash, at least in some quarters, against Citizens United, and of course, we'll see what happens in the future. But in the meantime, we have Citizens United, and because of Citizens United, the essential rule is, up to the very day of the election, any corporation or any person can give an unlimited amount to any political action committee, and that political action committee can go ahead and run ads on behalf of the candidate. It can't specifically be associated with the candidate. In other words, it can't be run by the candidate. It can't be controlled by the candidate or the candidate's organization, but it can be independent, and it can completely comply in order to the benefit of the candidate. So if you look around the internet, for example, this one, which is the Political Action Committee, the Super PAC for Mitt Romney, Restore Our Future. In the old days, you had, during the 2004 election, you had a whole bunch of different 527 groups. One of them was more militarily oriented and went after John Kerry because of that. One of them was taxation oriented and went after Bush because of that. Whatever. You had all these different little 527 groups. Now, without directly being affiliated with the candidate's campaign, essentially there's one big PAC, it's called a Super PAC, that's being set up for each candidate. Restore Our Future for Mitt Romney. For Newt Gingrich, you have over here, you can see this is Winning Our Future. Romney's is Restore Our Future, so Gingrich is Winning Our Future, I guess, same basic idea. And you can see it says specifically, Newt Gingrich, this is a Super PAC, and before Citizens United, you couldn't have had this. Before Citizens United, if it was 30 days before a primary, which obviously it is, since it's during the primaries, you couldn't have a situation where an organization like this would be able to specifically name a candidate and name another candidate and put the word blood money in front of him with a picture of Mitt Romney in the background. But after Citizens United, you can, as long as this is not specifically affiliated with Newt Gingrich. And of course, they don't try to make a secret of this. This is a Google search that I did on Winning Our Future. That's Gingrich's Super PAC, and it specifically says that welcome to Winning Our Future. It's a registered Super PAC supporting conservative ideals and Newt Gingrich for president in 2012. Other candidates also, even, I guess, second-tier candidates. We have over here Rick Santorum's Super PAC, which is taking shots at Gingrich and Romney. And I don't know if Ron Paul has a Super PAC, but I figure he probably does. They all do, so I guess why wouldn't he? Well, that's the world we live in now. So even though corporations cannot actually directly give money to a candidate or a candidate's campaign, it can spend an unlimited amount blasting or supporting a particular candidate, and they don't need to hide it at all. And of course, the only way that could be changed is if the U.S. Supreme Court changes its mind and goes back and reverses Citizens United and reenacts parts of McCain-Feingold. So that's my analysis of the Super PACs and how they came to be and to the extent that they exist now. Thank you very much for listening. Have a wonderful, wonderful day. This for the National Paralegal College faculty's legal analysis of the news. This is Stephen Haas. Have a great day.